Welcome to War Story Wednesdays. It's known now in California that in a residential real estate transaction, the broker has an obligation to conduct a reasonably competent, diligent, visual inspection of the accessible areas of a property and to disclose the material facts that that investigation reveals. Where did that come from? I want you to come back in time with me to 1984.
He slimed me.
That's great! Actual physical contact!
This happened with her soon. She called me to a room. Hey.
You are the purchaser of this wonderful house overlooking the Bay Area. It's a 4-bridge view. It's got a nice slope. It's got a house with a pretty deck. You can sit out there with your margaritas and watch the sunset over the Golden Gate day after day after day, because the fog is way up in Berkeley and this one isn't in the fog belt. It is the house of your dreams. You buy it up and you are just happy as hell. One of the things you want to do is build a pool. So you start excavating. And as soon as the trencher digs the 3rd scoop, half the hillside falls away. That beautiful deck starts to slope down the hill. The foundation of the house is undermined, and now you are looking at hundreds of thousands of dollars in repair bills. This does not make you happy. What do? You find out who knew and when they knew. Massive earth movement is the way that it was described. And it turns out that's not the first time this property had been subject to massive earth movement. Turns out that 3 or 4 years before, there had been a minor slide. And that about 9 months after that, there had been, well, something other than a minor slide, where a hole 8 to 10 feet deep and 50 to 60 feet wide had appeared in the middle of this property. It was made on fill. The fill hadn't been compacted correctly. The question became whether or not the real estate agents knew or should have known about the defect in this property. Until that time, the law had been that a real estate broker was responsible for disclosing the things that the broker actually knew. And here it was proven that the broker did not know that there had been landslides or slumpage on this property. Well, time out, said the court. Did the broker have reason to suspect that there would be landslide or slumpage problems? The question was whether the broker did an investigation, any investigation that would have triggered finding out about the landslide problem. The court found that the broker did do some looking around and some disclosures, and one of the things that they found was that there was netting on part of the land. And one of the brokers knew that there had been erosion problems in land near there, and that land on fill sometimes had erosion problems. Another broker said that, the guest house next to where the pool was going to go had a sloping floor. And a different agent said, well, sometimes sloping floors can mean that there's foundation problems. And while no one agent involved in the transaction had knowledge of all of those different pieces, the brokerage did, as an overall entity. And so the court found that, using a phrase one of the brokers used in a deposition, that there were red flags that would have indicated the potential of a problem. And that given the potential problem, it would have been prudent to advise the customer to get a soils engineer to come out and investigate. Potential problem means that the broker had to infer and take information that the broker didn't know with certainty and yet advise the client to do further investigation. That was an expansion of the duty then existing with regard to real estate brokers. So what did the court use to hang its hat to impose this duty? You know, trade associations like unions can be good things sometimes, and they can be bad things sometimes. And the National Association of Realtors is a trade association that you can either love or hate. It had a code of ethics in existence at the time. And in that code of ethics, it said, the trade association, based out of Washington, D.C., said that the broker had an affirmative obligation to discover adverse factors that might affect the value or desirability of the property. And that performing a reasonably competent visual inspection was one of the things that a broker should do under the code of ethics of the trade association. And the Court of Appeals said that's good enough for us and created the legal duty of a real estate broker to conduct that reasonably competent, diligent visual inspection of accessible areas and to disclose what that investigation finds. And to suggest that if there's netting on land-filled areas, that a geologic survey would be prudent. The broker got nailed for the costs of rehabilitation of this property because they didn't suggest that the buyer conduct further investigations, because the brokers saw what they thought of as red flags. So what's the takeaway on this one? Lots of times we'll walk into a house and see a crack in the ceiling, or you'll see that white efflorescence on the side of a garage wall, or some water stains near a foundation. Are those red flags sufficient to give you, as the professional, an obligation to suggest that your client get additional investigations? Absolutely. There is no such thing as a perfect house. And so when you see on a seller disclosure statement that the door sticks in winter, it's because it's warped and it's because it's not square. And it could be because the foundation is sliding away. To protect yourself, you should always advise a buyer to conduct additional inspections by competent professionals for every transaction.